again?
Yeah.
Is she trying to talk? Because we don't hear her. Does she know that?
I don't know if anybody's trying to talk,
Okay.
He was muted.
except for me. Welcome, everyone. I don't know if I'm doing anything in this meeting besides trying to get you all on. Does everyone know? I know the planning board all knows each other. Has everyone properly met our town attorney?
No.
Hi, Sally.
Hi, Sally.
I know, I see some familiar faces, but I also see some new faces. So welcome new board members, and I'm Sally Daggett, the town attorney, and here to help give you some training this afternoon, and pleased to start whenever you're all ready.
David, did you say Janice looked like she was on?
No, I do
Oh,
not.
okay.
I do not see Janice. Maybe I'll get off the microphone and maybe the video and try to make contact with Janice and Tom. But I wouldn't hold up. It's now a couple minutes after 4.
You said Tom. Oh, okay. What about Scott? Did we hear from him?
I have not. I can try Scott as well.
Is
Okay.
Bill on?
Bill
I
is
am.
on.
I think Bill is listening, but he was having some internet challenges.
Yeah, I just
I think-
turned off my video, hoping that maybe it'll, and it actually seemed to clear it up a little bit. So
Okay.
So, Madam Chair, do you want to start and
Okay.
have Sally start? And
Yes, definitely. Do we need to call this meeting to order, or do we just jump right into a workshop? And Sally, I love your outline. Thank you so much.
You're very welcome. All right, we'll jump right in, and I have a PowerPoint, so I guess, oh, Dave just left, so I can't share screen without, oh, wait, let me try here. Hold on one sec. Okay, are you seeing my,
Yes,
look okay? You guys see that?
yes,
Oh, very
Okay.
good. I'm
Got it.
impressed.
I'm impressed.
All right, let me just see if I can, hold on, my mouse is not working here.
I'm on Zoom.
Okay, I need to figure out how to, all right, there we go. Okay. All right, sorry, get the technical glitches out of the way. Welcome, everybody. This is your training workshop. I have a bunch of things that I can cover, but I want to make sure you get all your questions answered. The number one ground rule is that unfortunately you cannot ask me about any pending applications, because that's not fair to the applicants or the neighbors, and you all are going to have to police yourselves, because I don't necessarily know what are all the pending applications before the Lincolnville Planning Board. So please just be good sports about that. So I sent you up some written materials. Hopefully everybody was able to get a copy of those. It's really meant to be a resource. I will refer to some of the pages in those written materials, but I also have a lot of stuff in this slideshow. So I will start in, but again, feel free to ask questions along the way. I don't want this to be me, talking at you for 2 hours and putting you all to sleep. But I know that one of the things I want to spend some time on, if you may have seen in the written materials, are some of the timelines for different types of applications. So I want to spend some time on that, but also because there are a bunch of you who are new, I want to make sure that we go over some real background basics. But again, if I start going off too much on some of this good boardsmanship boardsmanship stuff and you feel like you already know all that, just say, Sally, we're all set with that, because I don't want to cover stuff, belabor stuff that you already are comfortable with. And I know that at least some of you went to a training recently put on by the Maine Municipal Association, and you didn't feel like it addressed some of your specific Lincolnville issues. So I want to make sure that we do cover your specific Lincolnville issues. So with that all being said, good boardsmanship. One of the fundamental things you all as planning board members, and this is true for Board of Appeals members, as well as for Board of Assessment Review members, which is different than, say, the Conservation Commission, or you have a sort of Recreation Committee, and different in some instances, the Board of Selectmen acts in a quasi-judicial capacity, but not relatively infrequently. But for planning boards and zoning boards, you all act in what is known as a quasi-judicial capacity, meaning you are sitting on applications like judges. And so that the law imposes a number of requirements on you as planning board members to be fair and impartial to everybody. And there's a lot that's involved in being fair and impartial. It means you don't talk or email about applications outside of the meeting. And that includes even calling up the code enforcement officer and saying, well, I got this application and I have some questions about it. And, Frank, will you answer all my questions about this application? Even that is improper when you're sitting as a planning board member, because the applicants and the neighbors don't get to hear that colloquy between you and the code officer. And if Frank tells you some information and then you rely on that information as a planning board member and that informs your decision on that particular application, nobody else gets a chance to A, learn that information, or B, correct that information if Frank got something wrong. So this business about not talking about applications outside of the meeting, be it to the code officer, be it to the applicant, be it to the neighbors, all of that is part of, you need to put your judge hat on and everything that you do as a planning board member. The only exception to this general rule is in some instances, the planning board acts in a legislative capacity. And that is whenever the land use ordinance or the subdivision ordinance gets amended, the planning board by state statute is required to conduct a public hearing. So in that instance, you're not sitting in a quasi-judicial capacity. You're not sitting on an application. You're just taking comments on proposed amendments to a land use ordinance. So, but the key point again about being put in a quasi-judicial role is that you want everybody to have the same information, because you want the process to be fair, and the only way it's fair is if everybody's working from the same set of facts. So let's see here. Another part of good boardsmanship is making sure you understand the applicable law, and there's the federal and the Maine Constitution, which comes into play, just this requirement of fundamental fairness, and the source of that requirement is quite frankly through the due process clause of the federal and the state constitution. There's state statutes that come into play. The main one for planning boards is the subdivision statute, but and it sets out the set of review criteria, which are pretty much incorporated into your ordinance, but sometimes state statute changes and you may not necessarily pick up on that, and the state statute still applies, even if your ordinance may lag behind in sort of being consistent with state law. So this, you have a charter. There are a couple pages about the planning board and the charter, but really sort of procedural type stuff. And then you have a set of procedural rules. I included those in your written materials. They're from 2007, but I think they look pretty good to me. I don't know how often you sort of look at them and see if they need an update. But if you're a new board member and you haven't seen those before, you ought to probably take a look at those. As far as ordinances that apply, it's the main ones that the planning board works with are both the land use ordinance, and I didn't list it here, but I meant to, that the subdivision ordinance, which is obviously a separate standalone ordinance. And just remember that those two ordinances are the main working documents for the planning board. And so if you're a new planning board member, and I know it's a little bit of a laborious task, but you ought to go and read through them and making sure you know what's in there. And I would say particularly the section in the land use ordinance, the two sections, the sections on site plan review and then on shoreland zoning. So site plan review is in section 18 and shoreland zoning is in section 16. If you're only going to read two sections in the land use ordinance, those would be and granted, they're more than a few pages, but those would be the two sections I'd look at. And then you ought to at least, familiarize yourself with the subdivision ordinance. And you have to understand as a planning board member that the policy that's, codified in those ordinances, that's set by the voters, and in the voters in Lincolnville, it's town meeting. It's town meeting that adopts and amends land use ordinances in Lincolnville, which is different in some other communities that may have a city or a town council. But you as a planning board member, you take the policy as it is. If you don't like the policy, then you may suggest, first to the selectmen, that, oh, maybe we ought to, change the policy. We may want to amend the ordinance, but you don't, as a planning board member, get to say, well, I don't like this requirement that the applicants submit a traffic impact study for every major site plan application. And so I'm not going to require that because I don't think that that is a good requirement. That's not your role as a planning board member. Your role as a planning board member is to make sure that the traffic impact study gets done, and then to find out whether, the results of that traffic study suggests that the applicant can meet the applicable review criteria related to traffic. So you got to understand the policy's been set, and the planning board is really applying that policy to specific applications. So in the written materials, there's a little bit of sort of what the planning board does, versus what the Board of Appeals does. I will just mention it now, but it comes up again later. The planning board does not get to grant what are called variances. That's when somebody wants sort of an exception from a specific requirement of the zoning ordinance. It tends to be dimensional standards. Let's say somebody doesn't want to comply with the side yard setback. They want to build a new house, but they don't want to comply with the side yard setback. They don't come to you folks as the planning board to get relief from that requirement. That goes to the Board of Appeals, and there are very specific criteria that are set out in state law, and only the Board of Appeals can grant variances. So that's a big deal. Okay, I'll stop there. Any questions so far on what I've just gone over? Nope. Okay, keep going. Next topic is just a brief overview of the Freedom of Access Act, also known as the Right to Know Law. This governs all state and local boards and committees and state agencies. It's in other states, it's known as the Sunshine Law, but this state statute applies to, again, every board and committee and the select board in the town of Lincolnville. And the policy of this state statute is that the people's business is done in public. And so there's both a public meeting as well as a public record component to the Freedom of Access Act. And It comes into play because basically you need to provide notice of your meetings with adequate time periods so that people who are interested in the items on the agenda can attend. It also requires that all the paperwork that relates to the business of the planning board, those are what are known as public records. And if somebody wants to come and look at them, they have the right to inspect and to copy them. It also governs emails. Any emails that you send that relate to town of Lincolnville business are considered to be public records. And if somebody makes a request to the town for those emails, you will get asked to provide all of those to the town so that they can be provided to the requester. Another issue that comes up quite a bit is under the Freedom of Access Act is understanding some of the terminology related to public meetings. Everything that the planning board does has to start at a public meeting. It may be that, so the meeting gets, so you got to give notice of your meeting, again, with reasonable time period for people to attend. It may mean that there are different items on your agenda where you don't allow public comment, but the public has the right to see and hear everything that the planning board does, generally speaking. There are some limited exceptions under Maine law where it may be permissible to go into executive session. And the only instance that I think the planning board might ever be able to, or be allowed by law to go into executive session is if you're meeting with the town attorney. Generally speaking, planning boards and zoning boards do not have executive sessions. They really just don't. There isn't a basis under the law for them to be going into executive session. If there is some legal advice you're seeking from me as the town attorney, generally speaking, whatever letter I send to the planning board, I say that is to be shared with the applicant and to the neighbors. Anybody who's interested in this particular application, they are entitled to that information. It is not an attorney-client privileged communication. And I write my letters that knowing that they will be made public, and they should be made public. It is unfair to the applicant and the neighbors for me to advise the planning board on some legal point, and then if they don't get a chance to respond to that. They may disagree with it, they may think I'm wrong, they may have lots of opinions on what I might advise the planning board, but they get to know what I advise the planning board. So that's another point to just keep in mind. There is a distinction under Maine law between a public meeting. Again, that's everything that you do should start in a public meeting, and maybe you go into executive session. That would be closed session. But there is also a specific portion of a public meeting where the public not only has the right to see and hear everything that's happening, but they have the actual right to speak. And so that component of a public meeting is what's known as a public hearing. So on certain types of applications, and we'll go through this in a bit, there may be either a requirement of a public hearing, or it may be permissive that the planning board may conduct a public hearing. And what distinguishes a public hearing from just a regular run-of-the-mill planning board meeting on the last Wednesday of the month is that the public has the right to speak at a public hearing. They don't necessarily, when you have on your agenda reviewing the minutes from the prior meeting, the public doesn't have the right to speak about those minutes. They have the right to see and hear you talk about reviewing the minutes from your last meeting, but the public doesn't have the right to speak. So again, public meeting is always sort of required for the planning board to conduct its business, but there may be a portion of it where the public not only has the right to see and hear, but they actually have the right to speak. And some boards are very loose about public comments, and they pretty much allow the public to comment on every agenda item. Other planning boards are much stingier with the amount of public comment they allow. And I don't know, I don't have a sense, because I don't go to enough of your planning board meetings, how sort of loose or stringent you are about allowing public comment, but there isn't a right answer. It's whatever is right for your community. But if your planning board meetings are going, hours and hours because, people are droning on for 15 minutes, on every single agenda item, or maybe even longer, then maybe you want to limit public comments. And it doesn't necessarily mean to be that you go to no public comment. It may just be that you put time limits on the time that public comment is allowed. So I've seen it's very common, and in some, there's can be sometimes some communities, huge applications. For example, I just did one up in Norridgewock where the waste management landfill needs to expand to a new phase. They're running out of room of the phase that they're currently in, and so they need more room. And so it was multiple, I think there were 6 different planning board meetings on that application. And so when it came time for the official public hearing, they imposed time limits so that we weren't there for, all hours of the night. So another topic to talk about is ex-parte communications.
Sally,
Yeah,
Jay Foster, can I ask one point on public comment?
sure.
In the handout, I had marked as a question for you on page 6, the quasi judicial and legislative rule listing. And under the quasi judicial portion of it, the very last bullet on there says the only relevant public comment is with respect to whether the application meets standards and whether procedures and submissions are in order. Can you explain that?
Well, if the when you're, and that's specific to an application, I think that standard. Generally speaking, if you have folks that are coming to, talk about, say, this came up in Norridgewock on this waste management landfill expansion application. There were a lot of folks that wanted to talk about things that were not within the purview of the planning board. They wanted to talk about some other issues that were not germane to the planning board application about, and I won't go into the specifics, but so it's up to the planning board to decide how much it wants to allow public comment that isn't really germane to what the planning board is doing. It could be that people want to come in and talk about, the applicant, it's him or herself personally, on stuff that's unrelated to the applicant's, planning board application. And it's really up to the planning board to police those kind of comments. But technically, the only public comment that really is germane to the planning board is if it relates to, the application and whether, it's complete, whether the submittals are appropriate, and whether the applicant has met the substantive review criteria, and whether the applicant has, some issue in his or her personal life, is the applicant is, beating his wife. That is not germane to the Lincolnville Planning Board on a planning board application. And I think you ought to step in and reel people back into, we're here on the, site plan review standards and not on other things. I know this has come up a lot of times on certain applications where, an applicant may have multiple applications. Maybe they'll have an air emissions license. They may have an Army Corps of Engineers license application. And the applicant, and sometimes the neighbors may want to talk about some other issues, but aren't really specifically about the, local ordinances that are at issue. It may be DEP or Army Corps of Engineers issues. And, you just want to put that aside and say, yeah, it may be true that the applicant needs those other approvals in order for the project to go forward, but the Lincolnville Planning Board isn't going to turn into, the DEP air emissions police. So that's the point there. All right. Site visits, I guess, let me back up here, sorry. As relates to the public meeting laws, site visits are treated just like any other public meeting. They have to be noticed, and so that the public has the right to attend. And site visits can be a recipe for disaster because there are a lot of sidebar conversations, and you want to try and avoid those when you're conducting a site visit. But for site, if the planning board wants to go on a site visit, that's fine, but you gotta let everybody know when you're gonna do it. And you gotta give notice, you gotta invite the applicant, you gotta invite the neighbors, and you gotta try to avoid all the sidebar conversations. Because the point of a site visit is really to better understand the evidence in the application. It's not to sort of take new evidence. It's to understand the evidence that gets presented at the planning board meeting. You want to make sure those get noticed as public meetings. Ex-parte communications, that's a fancy term for information that gets provided to a board member outside of the public meeting. It could be that an applicant, sees one of you at the grocery store and wants to bend your ear about why her application should be granted. And it could be that, you bump into somebody at the grocery store and you start inadvertently say, oh, I liked your presentation the other night at the planning board meeting, and here's what I thought you could have done better. All of that is inappropriate, because remember, it all goes back to you all sitting as judges on applications, and you want to be fair to everybody. And being fair to everybody means you don't talk about the application outside of your Wednesday night meetings. So it's understandably, you live in a small community, people know one another, and sometimes things happen inadvertently, but you want to try to avoid talking about applications, again, with the applicant or the neighbors or the code officer or your fellow board members. You want to try and avoid all those types of discussions. But if they do happen, there's a way to try and cure that situation. That is, at the next meeting on the application, you need to, as soon as that agenda item comes up, you want to disclose that the ex parte communication took place. You say, look, I ran into the applicant at the soccer game on Saturday morning, and unfortunately I slipped and allowed the applicant to bend my ear a little bit on the application, and here's what the substance of the conversation was. So you disclose the conversation so that then everybody, your fellow board members, know that that's happened. And if the opposing neighbors, or somehow want to respond to that colloquy that you had at the Saturday morning soccer game with the applicant, they can respond to it. So that's only fair. Another point, and it's probably the bane of everybody's existence, is that the freedom of access law has certain written decision requirements. There are two instances where by law, this is state statute, sort of no matter what your ordinances say, if you deny an application or if you grant an application with conditions, you're supposed to do a written decision. And certainly for subdivision applications, where those get appealed straight to Superior Court, there isn't an intermediate appeal to the Board of Appeals, it is imperative that there be a thoughtfully done written decision, so that if there is an appeal to Superior Court, somebody's unhappy, because that's one of the first things the Superior Court will look at is how well the written decision has been drafted, because if it hasn't been done right, the court's going to send it back and make you do it again. The only other thing, and then I'll move on from this right to know law topic, is
Sally, one more question.
Sure.
The material you sent out has a Town of Richmond Planning Board Notice of Development Review Decision. That's a written decision.
correct.
That's 13 pages long. Who writes that decision?
They have a template, and sometimes it's the applicant. And if it's a big application, sometimes the town attorney gets involved. But they have a template that they use.
And that's for any and all decisions made by the board?
Correct. Yep. I mean, that one is probably one that we have it here at my office, probably because we were involved in it. So I would say this one is definitely one that my office, I know it wasn't me, but my office was involved in. But it's just, and in Richmond, development review is what they call site plan review. You can see the next sample, which is on page 44. That's my example of a template, which the Booth Bay Planning Board uses. And you can see it lays out all of the substantive review criteria, and then it has a little bit of a space and the planning board does these themselves. They fill in what evidence is in the record that shows that the application, meets that substantive review criteria. And yes, we're going to talk some more about written decision. Is it a major pain in the butt? Yes, it doesn't have to be as bad as it looks, but yes, it is a pain in the butt.
We could use this as a template and create our own.
Oh, absolutely. I at one point I thought you had some templates, but it may be that you've just gotten away from using them. But I know I thought there were some templates, but that's something we can talk some more about. The only other thing I want to say about the right to know law is that, as you know, during the pandemic since last March, local boards and committees have been allowed to meet remotely via, Zoom or whatever other technology people use. And we think that the legislature is going to allow that to continue in some fashion after the pandemic is over. But just for now, you just want to keep in mind that, and this is required currently by state law, if a board or committee is meeting remotely and using Zoom, all votes have to be roll call votes. So when you are going through, the site plan review criteria, and it seems really laborious, but yes, somebody's got to call the roll for every single motion that you take on that application. So just keep that in mind.
Can we use first names, or do I have to say member Foster and member?
Whatever
Delano?
you are most comfortable with.
Okay.
You have to be able to identify the board members is the point.
Okay, great. Thank you.
When you say identify them, you mean by voice?
Yes,
You call the roll. So,
for every vote.
Mr. Foster.
How do you vote,
nay,
Mr.
or you
Foster?
say nay.
Does the answer have to be by voice, or can you put the raise hand business up there, or to raise your
You have
hand
to-
up, or it has to be
Your voice.
voice? Okay.
Yes. Okay. So my last, I think, slide on good boardsmanship is about being an impartial decision maker. What does that involve? Remember, big picture. All board members are to participate on every application unless they're either recused or they have been excused because they have a conflict of interest or are biased. And a recusal situation is, generally speaking, when something is so obvious, if it's Dick's, brother, who's the applicant, then it's inappropriate for Dick to be sitting as a planning board member on that application. And so you'd say, look, the applicant's my brother, I'm recusing myself. But the recusal is only when it's really, really obvious and that nobody would question it. Otherwise, if there's this, if it's not blatantly obvious about there being either a conflict of interest or a bias issue, we're going to walk through how you handle a conflict of interest or a bias situation. But generally speaking, it's only if the balance of the board, other than the planning board member who might have a conflict of interest or be considered to be biased, it's only when the balance of the board decides that you're excused, that you are truly excused. And if you are excused, you in normal times when you're not meeting remotely, you would go and you would sit in the audience. So it's clear that you are not participating as a board member. I've seen this happen where somebody's, been excused and they sit up in the front of the room and they ask questions as if they're a board member. And that is a huge no-no. You can still, if you're, excused, you can still participate as a member of the public, but it's clear you sit in the audience and you participate only in the same fashion as a member of the public would participate. So two things come up occasionally as on different applications. One is the issue of conflicts of interest, and there's some materials or some information in the materials on this, but there are sort of two tests for conflicts of interest. There is a statutory test, and I included the actual statute, and there's also a case law test, and the case law test tends to be much broader than the statutory test. So if you were just looking at the statute, you might think, well, hey, I don't have a business interest in this application. I don't have a personal financial interest. I'm good. But no, there is a case law, meaning it's judge-made law of the state of Maine that is a much broader concept of what's a conflict of interest, and we'll talk about that. But generally speaking, for the statute, which is in pages 12 and 13 of the handout, that speaks to whether a planning board member has a business interest, meaning are you an officer, a director, a partner, a shareholder of a business. It also speaks of whether you have a personal financial interest in an application, meaning are you the owner of 10% or more of the business? And in that case, the law of Maine says you are right, de facto have a conflict of interest and you should not be participating in that application. The statute also talks about, there's sort of a catch-all, which says that all board and committee members are to avoid the appearance of impropriety. And so that sort of gets into a little bit like what the case law test is. And that is, again, you're doing the people's business and you're acting as judges and you want this process to be fair. So what does that mean? You got to have, fair and impartial decision makers. You can't have decision makers who have conflicts of interest. So if it doesn't look good, then you ought to, raise the issue. And that's another point on these conflicts of interest issues. And that is that it's very embarrassing to have somebody else, be it one of your fellow board members or the, opposing neighbors, raise this issue about, does the chair have a conflict of interest? Why is she participating in this application? You as the board member ought to try and take the initiative on these things. And if you think there might be an issue, you ought to raise it, and you raise it at the start of the agenda item on that application. You don't sit through all the applicant's presentation and then all the neighbors, public comment, and then it gets to, you've closed the public comment session, and then you start deliberating on the application, and then all of a sudden you say, oh, by the way, I think I might have a conflict of interest. You have to do that at the start of the agenda item. And how you handle, and this is in the written materials, just so you don't have to memorize any of this, but how you handle a situation where you think there might be an issue of having a conflict of interest is you disclose the issue on the record, you as the board member, to explain the situation. We had one come up recently in a town where the planning board was considering some land use ordinance amendments related to medical marijuana. It was a hot topic throughout the state because of some recent changes in state law. So one of the planning board members is a landlord in town, has it used to be a large sort of industrial building that's now been converted into separate spaces for a whole bunch of medical marijuana caregivers. And these have basically been unregulated up until this town decided they wanted to rein this in a little bit more. So that planning board member was there. And granted, it wasn't an application, but it was because it was the planning board having a public hearing on these medical marijuana land use ordinance amendments. But even so, given that this was the sort of the only game in town as far as where these quite a large business of these or a large location where a number of medical marijuana caregivers were. And so these ordinance amendments were going to affect this landlord's, tenants quite, dramatically, quite frankly. So again, even though in that instance, it was the planning board member, sitting in a legislative capacity, it's back on this avoidance of appearance of impropriety. It just didn't look good that for sort of the one game in town, the one property where this is a big issue, and these ordinance amendments would have a very direct, specific effect. The better, discretion is the better course in that instance. And so I think that planning board member said, look, and it's also a small town. Said, look, I have the largest property that has all these and pretty much the only in town. I'm not going to participate in these ordinance amendments, because in that instance, the planning board was just making a recommendation on whether these ordinance amendments should be approved by the voters. So to handle these conflicts of interest, you disclose on the record, you state whether you can be fair and impartial, and then you let the balance of the board make a decision. And I guess I skipped over the case law test, but this is in the written materials. In addition to the statutory language about, conflicts of interest that again tends to focus on business and financial interest, there is a more large concept of conflict of interest dictated by the decisions of the Maine Supreme Court. And it basically asks the question of, are you as an individual board member being put in a situation where you have your own personal interest that is some fashion is in conflict with your interest or the town's interest in you being a fair and impartial member of the planning board? So are you being put in a situation where you have to wear two hats is ultimately what the case law test is about. And on page 2 of the materials, I gave you the quote, which is a little bit lawyerly, but it's because it's from a court case about, are you being put in a situation of temptation to serve basically your own personal interests to the prejudice of the interest of you as a town official? So that's
Sally,
yep, go ahead.
a comment on that. I think it's important that the select board of any given town be aware of what you just said, because they're the ones that appoint members to the planning board. And over the years, we've had people who have joined the planning board with an agenda. I remember we used to have one member that we called the buffer lady, because everything that came through was applied for had to be buffered, and so it was to be camouflaged and made to go away. But it's very important that the select board know that people with an agenda who are looking possibly to get something changed in the town should not take the course of joining the planning board in order to accomplish that, because we do see it from time to time.
Good one, Jay.
Well, I guess I would say this, that just because an individual, your example of somebody who wants to, require buffers, that doesn't necessarily mean she has a conflict of interest under the law. It may be that she's trying to apply a standard that isn't in your ordinance, and it may be that that's inappropriate, but I wouldn't necessarily say that because somebody has an interest, in whatever it may be, landscaping or, signage or lighting. And if they have they're always that particular board member is always looking at that specific issue very closely. That doesn't necessarily mean they have a conflict of interest in the terms of the law. It may just mean that they're trying to basically apply a standard that's not in your ordinance. And it could be that this board member wants to advocate to amend the ordinance to beef up your buffering or your landscaping requirements, and that's appropriate, but that takes the voters of Lincolnville to do that. It's not. So I think it's different concept than conflict of interest or bias, quite frankly, because it doesn't relate to a specific application, and parties to a specific application. So the other part of being an impartial decision maker is making sure that you're not biased. And what does it mean to be biased? It means you have a predisposition either for or against a particular application. And as I said earlier, the policy's already been set by town meeting. So if you, as I guess, use your buffer example, if you as a planning board member don't think that the buffer standards in the land use ordinance are substantive enough, then it doesn't mean that you deny an application that doesn't have a lot of buffering. It means that you ought to seek, changing the ordinance. And that's a slightly different concept than bias even. But bias is a predisposition for or against a particular application. I can give you an example, and that is up in Jay and Wilton area, the CMP corridor project, it goes through both communities, and there have been a lot of local folks involved. They were involved in trying to get a petition together to put the question of the CMP corridor project on the November 2020 statewide ballot. And so there were a number of folks in both Jay and Wilton that had been involved in this petition drive, trying to get enough citizen petitions to bring the question forward to the state voters. And then this past summer, CMP has a shoreland zoning permit application in front of the Jay Planning Board. And one of these citizen petitioners, who had been, again, very active in this drive to try and prevent the CMP corridor project, was on the Jay Planning Board. And so before the planning board could even get started on the shoreline zoning application, the board had to work through, it's a 5-member planning board. 2 of the members had been very active petitioners. And then there was another board member who just had a lawn sign out, stop the CMP corridor project. And so the planning board had to work through, the process of, and the 2 women who had been very involved in this petition drive, they stated that they could be fair and impartial. I mean, they made this disclosure. It was no secret. They'd been involved. Their name was on the petition. And they made their disclosure about how they still thought they could be fair and impartial. And then the balance of the planning board made a decision about whether they could participate or not. So that wasn't a conflict of interest issue. That was really a bias issue. I mean, there was no question these 2 women were anti-CMP corridor project. The other thing on good boardsmanship is, what do you do if you miss a meeting? And if application's going to take multiple meetings, it's not the end of the world, but you do, and this is addressed, and I gave you the site. It's in your bylaws. Your bylaws specifically allow you if you miss, if it's a 3 meeting application, if you miss meeting number 2, if you go and make sure you've read the materials from meeting number 2 and you listen to the audio tape, if there is one, hopefully, or videotape, and you look at the minutes and you sort of bring yourself up to speed. And then at the meeting number 3, you state on the record what you've done to, you've done your homework on meeting number 2 to make up for the fact that you missed the meeting. That is permissible. But you just need to put it on the record that you've done that. And then you can participate in meeting number 3. And the last point about if you miss a meeting, can you vote on the minutes? I see this comes up all the time. Members say, "Oh, I wasn't there, so I can't vote on the minutes." The act of approving the minutes is ministerial. You don't have to have been there, and quite frankly, sometimes it's good to have another set of eyes to pick up on some of the typos or to make clarifications. So if you missed a meeting, you can still vote on the minutes of that meeting. Okay, that's what I
Quick
have
question.
on good boardsmanship. Yes, go ahead.
Somewhere in our materials, there was a statement of a requirement that if you miss a meeting, you have to make a document and get that notarized. But that's not the case.
Your bylaws don't require that. I don't know that, I know that MMA, the Maine Municipal Association, they have like this form affidavit that they say that a board member should fill out if they miss a meeting. But our more practical advice is that's a little bit over the top. As long as you do, quite frankly, what your bylaws specifically provide for, I think a reviewing court would find that to be perfectly acceptable. But the key is you got to remember to do it. You got to remember that, oh, I missed meeting number 2. So at meeting number 3, I need to let everybody know, because again, you want to be fair to the applicant and any opposing neighbors, that you as a planning board member have all the same information as everybody else before you make a decision on an application. All right, any other questions on boardsmanship? Okay, we'll keep going. I'll try and pick up the pace here because we got a lot to cover. Preparing for and conducting a meeting. I think one of the questions I saw was sort of who handles getting ready for a meeting, and that, quite frankly, is the front office staff, but mostly headed by Frank as the code officer. And if there needs to be some further discussion about maybe improving those procedures, obviously that's something that you ought to sit down with the code officer and whoever else in the front office staff, about who's doing what. I quite frankly don't get involved in that piece of it, but it's really the code officer that sort of staffs the planning board. And so if there are some ways to improve the procedures there, you ought to have those discussions with Frank and any of his staff that may be involved. I did include in the written materials a sample opening remarks. I don't know, is that something that you have been doing at the start of every meeting, is having the chair read a set of opening remarks?
Yes, but not to this extent. This is great.
Okay. Yeah, I just think it's helpful because you all forget once you've been on the planning board for a little while and you've, you feel like it's old hat, and I know it's painful sometimes to listen to these opening remarks at the start of every meeting, but you don't understand how helpful that can be for somebody who's coming to the Lincolnville Planning Board for the very first time. They have no idea how it's going to work. They don't know if they should be talking, to the code officer or to just the chair or the board as a whole. Should they, do they have to come to the podium or not? And, how does it work? And so I think it's helpful and again, everybody have patience, but I think it is good practice for the chair at the start of every meeting to just go through the procedures, pretend like it's, your mother that's coming to the planning board for the first time. What does your mother need to know about how this process is going to work? Again, it's part of being fair and inclusive. And so I think it's just a good practice.
No, I like it very much. Thank you. It would be a big help.
I have a sample set of ground rules for a public hearing. Again, sometimes time limits are imposed and sometimes they are not. You can see in the sample that I gave you, the first one, which is on page 18, doesn't have a time limit. The second one has a time limit of 5 minutes. But I think again, too, if there is if there are a bunch of people, it helps again to just read the ground rules, just so everybody's on the same page. And also it can help, you can see, to remind everybody what the public hearing is about, that you're soliciting comments about the substantive review criteria related to a site plan application. This isn't about whether, the applicant has some issue in their personal life that, somebody from the public wants to complain about. This is about, planning board site plan or planning board subdivision or planning board shoreland zoning rules. And whether, does the application meet those rules? That's it. I included for sort of new members, a little cheat sheet on real basic parliamentary motions. I know the one that, was quite helpful is, if you want to take a break, how do you ask to take a break? And that's, you move to recess for, 5 minutes. And again, even tonight, if we need to take a break, you can practice. Well, let's take a recess for 5 minutes and reconvene at 6:02. But those are some real basic things that might be helpful for new members. Then the other thing just to point out is that your bylaws say specifically that you act by a majority vote, but it's a majority of the planning board. And it's nice that you have alternates, because you can probably always have at least 4 or 5 board members and not have a situation when there are only 3 of you present. But in some communities, if they don't have this requirement of a 3 affirmative votes to grant an application, the question becomes, what if only 3 board members are there and the vote is 2-1? Does that approve an application or not? And you guys don't need to worry about that. 2-1 vote does not approve anything in Lincolnville, because your bylaws are very clear that it takes 3 affirmative votes. You got to have 3 votes, whether it's site plan, subdivision, or shoreline zoning. 2-1 does not carry the day in Lincolnville. Let's see. Okay, the next slide is about different applications. And in your written materials, there are 3 different timelines. And I know they kind of all look the same, but at the top, you can see what makes them different. The first one is about site plan. The second one is about a major subdivision. And the last one is about a minor subdivision application. And so I'm not going to go through this line by line, but you can see that you really need to focus on the requirements of your ordinance to make sure. There are a lot of steps. Some may argue too many steps, but again, that's a decision for the voters of Lincolnville to make. If maybe your procedures are lengthier than they need to be, but currently this is the law of Lincolnville. And you can see that for a planning board, it could take, 3 or 4 meetings to approve a site plan application. For a major subdivision application, it could take, if, and I, in my example, walking through all the different, because you have to, for a major subdivision, there's both a preliminary plan application, and then once the preliminary plan gets approved, then the subdivision applicant goes off and spends time and puts together the final major subdivision application. So in effect, there are two separate applications. So that whole process could take, 10 to 12 meetings. And that seems like a really long time, but that's what your ordinance calls for. Then for a minor subdivision application, it could take as many as, 7 or 8 meetings. Have you had any major subdivision applications of late?
Yes,
Okay. And how many meetings did you process it in?
I believe it was 3 or 4.
With both a preliminary and a final?
Yes.
Yep.
Sally, question on commercial site plan. The commercial site plan ordinance in Lincolnville does not require a public hearing. However, the board has in the past deemed it important to have a public hearing because there was public interest. Is that a conflict of the ordinance, something that's allowed under the board's own discretion?
No, I mean, I would say that, most, I mean, the requirement of a public hearing becomes very important if you're one of those planning boards that doesn't allow public comment unless it's a public hearing. But because remember, the point of a public hearing is not only does the public have the right to see and hear what's happening, it has the right to speak. Some boards are more niggardly about how much public comment they allow. And so it's very important for them to conduct a public hearing so that there is some opportunity where the public has the right to speak, not just to see and hear, but to speak. But the other thing about a public hearing is that there's a notice involved, typically in the newspaper, and notice to the abutters. And I think that, the more public input, the better a project the town is going to get. And remember, it's the town, it's the community that's going to live with this project. So the more notice there is and the more chance for, members of the public to participate in the process, the more likelihood that it's going to be a better project for the town. And also, to the extent there might be some, neighbors who are opposed to the project, to give them an opportunity to get their concerns heard. They may not ultimately like the outcome, but I think having a process where they can at least feel like their concerns are heard by their fellow townspeople is a very important thing for the process. So I would say that, if you have the option of conducting a public hearing, I would recommend that, yes, you should conduct a public hearing because of all of the good that comes out of a public hearing, of having there be, input, and the project gets vetted and you all learn more about it, and, so do the neighbors.
I agree with all that. The point of my question was that it's not required in the ordinance, but the board has the discretion to do it.
Oh, absolutely. Yeah, the ordinance says that specifically. Yes. For site plan, I can tell you, it says, just trying to find it here. I should have used different headers here because they start to all look the same here.
Well, it's in our subdivision ordinance. I know that. It's in the land use. I know that. It's not in commercial site plan. We've always just understood that we have the discretion to have a public hearing because of
absolutely
public interest, even though it's not in the ordinance.
Yeah, I mean, it doesn't, you certainly are giving notice to all the abutters within 500 feet of the project. In my view is, if you're giving them notice and then you're telling them to come, but you're not allowing them to speak, that doesn't make any sense. So.
Well, that can be done in the context of a meeting if the chair allows that. I'm talking about a public hearing that's scheduled and notifications given and it's on the agenda.
I think you have absolutely the inherent authority to conduct a public hearing on a site plan application, even if you don't think that the ordinance says that expressly. The planning board has the inherent right to require a public hearing.
Okay.
Absolutely. I think that's what's intended by this whole, notice to all the abutters within 500 feet. I don't know why you'd give them these individual notices and then tell them they can't speak. So, just and you may not necessarily have these materials handy, but if you look at the site plan application timeline, there are a lot of steps, and it probably makes sense to just read through these and make sure that you all sort of know what the process is, because at the very outset, a project is supposed to get classified by the code officer as either minor or major. And there's sort of slightly different procedures depending on whether the project is a minor or a major site plan application. So you as a planning board member ought to be sure you understand right up front, is this a minor or a major subdivision application, and what that means for the process that's going to be involved. And then the applicant has the ability, even before it files an application, to seek a determination from the code officer about whether a project is major or minor. And then if they don't like the code officer's determination, they can appeal it to you. So that's before they've even filed an application. I don't know if anybody's ever done that, but just you ought to be aware that that is provided for in your site plan review standards. So does anybody have any questions about the site plan timeline for what's what?
Well, I'll take the opportunity to ask a couple. In this slide, you have three types of applications: site plan, subdivision, shoreline. Where does zoning fit in this? I'm sorry, I'm new at this, but where I come from, zoning is a very big deal. And is there such thing as a residential zoning, and does it have its own planning?
Really, Lincolnville is like a lot of smaller communities in Maine that basically it has shoreland zoning with a number of different zoning districts.
Right.
But then everything else that's not in shoreland is considered I don't know what you call
General
it.
district.
So there's
General district. Yeah, everybody has a different, yeah.
If you read the comprehensive plan, it explains the districts and the zoning. But zoning was a very, very volatile word to be used in Lincolnville for many years. It's not a very popular concept. And the comprehensive plan was designed around the districting, but no zoning was even mentioned in the comprehensive plan.
Okay.
Yeah, so Bill, if you look at the table of land uses in the ordinance, which is section 14, you can see that it's a big chart with all the different uses that the shoreland zone has 6 different sub-districts, and then it's so there's shoreland, and then there's everything else, which is the general district. And there are a lot of communities that do this way.
Thank you. Yeah,
so
that
you
makes
may
sense.
be thinking that there's a residential 1, a residential 2, and a commercial, and a business commercial, and an industrial. Well, that's not what Lincolnville has.
Excellent. Thank you. So there's shoreland and everything else.
Shoreland and general.
And
district.
general. Okay. Thank you.
Well, the shoreland zoning and the land use ordinance is based on the state shoreland zoning law.
correct, but yeah, yep.
That's not a designated zone by the town of Lincolnville. That's because of the shoreline zoning law.
No, these sub-districts are specific to Lincolnville. The state statute requires all communities with shoreland property, or I guess shoreland areas, to zone them. But like, for example, these you have stream protection and resource protection. Those are pretty common in this. Well, let me back up. State statute says every municipality with shoreline areas got to have a shoreland zoning ordinance. And if a community doesn't adopt a shoreland zoning ordinance, the state will impose one on the community. And there are some communities that didn't want to have to deal with it, so they had the state of Maine impose an ordinance on them. And the state of Maine, through the DEP, has adopted what's called the Model Shoreland Zoning Ordinance. And so every community in the state of Maine, either they have a state-imposed shoreland zoning ordinance, that's basically the state's model ordinance, or they have to adopt an ordinance that is consistent with this state model ordinance. And that state model ordinance is sort of the minimum requirements. But these specific zoning districts, for example, limited residential, harbor district, limited commercial, those are specific to Lincolnville about how they get defined. The state does allow, there is some sort of ability to wax and wane from the specific model ordinance, because every community is different. Some communities have oceanfront and some have lakefront or riverfront. So the types of shoreland areas differs from community to community. So it's not fair to say that Lincolnville's ordinance is just like the state model ordinance, because it's not. It's consistent with the state model ordinance, but it is not exactly the same as the state model ordinance. Because again, the state model ordinance it's a floor. It's a minimum requirement. You can always be sort of more restrictive, but it's subject to local changes, because every time you make changes to the shoreland zoning provisions of the Lincolnville land use ordinance, those have to get sent up to the commissioner of DEP for approval. We did a minor tweak a few years ago, I guess in 2019, related to single family houses in the resource protection district. And once town meeting approved those, they went up to DEP for approval. So that's that. Okay, any other questions on the timelines for either site plan or subdivision?
Real quick, is there a basic way of distinction between the major and minor subdivisions and site plans and that sort of thing?
Yeah, it's in your ordinance. For major and minor for site plan, I gave you it's section, and again, section 18 is your commercial site plan. And then within section 18, it's section 6.1 and 6.2 distinguishes between a minor versus a major project. So a minor is the construction or addition of less than 4,000 square feet, non-residential floor area, and fewer than 3 dwelling units. That's a minor development.
Sally, I'll go read it just to say.
Okay. Yep. All right. Any other questions on the timelines? Okay, moving on right along here. This slide is about the difference between submission requirements and substantive review standards, because it seemed like maybe from some of the questions that I got, there might be a little bit of confusion about, for example, requiring, some letter from some outside agency. Is that a submission requirement, or is that does that relate to a condition of approval so that the applicant can demonstrate that the application meets a substantive review standard? So I'm going to send everybody this slideshow, so you don't, if you, I know this isn't all in the handout you already received, but I will send, or I'll get David to send out these slides, so you'll have all this. But a submission requirement is something that the applicant has to provide to the planning board to make their application complete. So and I listed, and you have quite a lot of requirements, but to make a site plan application complete, you can see all those various sections that rattle off all the things that, need to be on a site plan application, stuff that needs to be on the plan, and then additional sort of narrative reports that need to be submitted about, surface drainage, hydrants, easements, there's landscaping, buffering, if there's buildings involved, location, dimension, ground floor elevation, those are all submittal requirements. But then whether an application meets, the substantive review requirements, that gets into, and there are 3 different sections in your site plan ordinance about, with substantive review standards. There are these general standards, there are these good neighbor standards, and then there are these design standards. So it's a lot. But that's once an application is complete, then you get into applying these substantive review standards to all the information that you've received. So you have a very thorough site plan and subdivision ordinance. And these were they all predate my law firm representing the town, but I think they're well done, and you may debate whether it's too much, but again, that's so as of right now, this is the policy of Lincolnville, that you have very thorough both site plan and subdivision ordinance provisions.
Ellie, I think it's understood that everything that's in the submission requirements are there because it's going to be later reviewed by the board and the review standards. So the reason all those submission requirements are there is so that there will be on the plan that's going to be a substantial review by the board when they review the standards.
Exactly. I don't think the town or the planning board shouldn't be asking for extraneous stuff that if it doesn't relate to a substantive review standard. I mean, there's no reason to ask for stuff that the board isn't, going to need for its substantive review. That's, and I don't think there is, but you all would know better because you've, walk through submission requirements, and then once you've got all that information, you've gone through the substantive review standards to see if you have everything you need to make a determination about whether the application meets all those review standards.
So this document has, with regards to the criteria and standards, it's a what you might call a nested document, I guess, where there are multiple levels. And how fine or coarse does the voting have to be, and particularly the information that gets put in the minutes? So for example, section 11.9 has got a sub-level of A, water quality protection and so forth, and then 1, 2, and 3 beneath that. Is it okay? Is it sufficient to say that the information provided satisfies 11.9, or do we have to go to 11.9A and separately vote on that?
I would say it depends on whether there's an issue about groundwater protection. If there isn't an issue with groundwater protection, I think it's sufficient to just say, I move to find that the applicant has met the standards set forth in section 11.9 relating to groundwater protection. But
Okay.
if there's an issue about groundwater, then you ought to discuss it further, and you may need to parse out, the various, 3 subsections there. But generally speaking, yes, this is you don't want to be spending, 4 hours, going through the review standards, every application. You'd only be able to do, one application, every 2 months at that rate. Okay. The next slide is just a little bit about, just so you're clear on the terminology, since some of you are new, there's a difference between a waiver and a variance. And I mentioned variances before, and that's something that only the Board of Appeals can grant. And there's specific standards for them. They're generally speaking very hard to get. I always tell folks that if they want to say yes to applicants, they should go on the planning board, because generally speaking, most applicants meet the site plan or subdivision review standards. But if they want to say no, they should go on the Board of Appeals, because 97% of the time an applicant is not entitled to a variance. But variance is a term of art, and it's to be distinguished from a waiver. And both your site plan and your subdivision ordinance provisions have a waiver allowance. And a waiver is when you basically allow an applicant to not have to submit something, a required document, because it may not be, if somebody's coming in for site plan review and it's an existing building, then you may not necessarily, that's already there, and they're just changing the use inside the building. They may not necessarily need to submit some, building elevations and some of the other stuff that may be technically required under the long list of submittal requirements for a site plan application. So you can waive that requirement if you think it doesn't apply. But just, you want to make sure you're using the right terms about a waiver of a submittal requirement. But a variance is when somebody is getting permission to depart from some requirement of or some substantive review requirement of the ordinance. Like my example about setbacks. And it also comes in a lot of time on height or minimum lot size, that kind of thing. Those are typically variances. And then waivers, again, are permission to not have to submit something.
Sally, I think it's really important to emphasize our waiver business that both the commercial site plan and the subdivision, and maybe even the land use ordinance, emphasizes that the waivers are for submission requirements and not the standards.
Correct.
There's always been confusion on that by some board members. And when we talk about the waivers that are in the ordinance that we would even discuss with an applicant, or the applicant would write to the board and request, only have to do with submission requirements, not the standards.
Correct. It could be that a standard doesn't apply to a particular application because the land use activity doesn't implicate the standard. But that wouldn't be a waiver. That's saying that standard doesn't apply to the proposed activity.
Right.
So just, yeah, unfortunately, the wording is important, the wording that you use. So then the next thing to talk about is conditions of approval. And I think Maine law is clear that planning boards and boards of appeals have an inherent authority to condition approvals, but your ordinance, quite frankly, expressly says so. But conditions of approval, there's one, and it's quite frankly is mentioned very specifically in your site plan ordinance, but the sort of language that what those in this practice area call the standard condition of approval. And I gave you the text of it. It's on page 31 of the written handout. But the standard condition of approval, when somebody starts talking about the standard condition of approval, it's basically something that you have on you should be on every subdivision or every site plan that you approve. And it basically is a condition that's of approval that says that the property that's shown on this plan can only be developed and used as depicted on the approved plan, and all features and elements of the plan, and this is key, all representations made by the applicant in the record of the planning board proceedings are conditions of approval. No changes from the conditions of approval are permitted unless an amended plan is first submitted and approved by the planning board. Your ordinance actually does allow some de minimis changes to be approved by the code officer, but we recommend to all of our planning boards that whether it's a site plan or a subdivision, even a shoreland zoning application, that you have this standard condition of approval just on everything that you approve, because it catches folks. If somebody has represented during the course of the planning board meeting that they're only going to operate from 10 a.m. to 8 p.m. And then they start deciding they're going to be open all night long, and they're residential properties nearby, I think that's an issue. And that isn't what the applicant got permission to do, was to operate from 10 a.m. to 8 p.m. They didn't get permission to go from, beyond 8 p.m. So if you haven't, during the course of the planning board proceedings, called out the operating hours for that applicant in a specific condition of approval, you be able to catch them with this so-called standard condition of approval. But that being said, it is still really, really good practice. If there is something specific about an application that you want to make sure there's no question about, that you want to hold this applicant and any future owners of the property to this requirement, you ought to call that out with a specific condition of approval. And the big thing about conditions of approval is there has to be some sort of a relationship or a nexus between the condition that's being imposed and some substantive review criteria. So for example, the issue about lighting, it may be that you want to impose specific requirement that the exterior lighting has to be turned off by 9 p.m. All the time, because that relates to the provision in the site plan review ordinance about how the lighting isn't going to detrimentally affect the neighboring properties. Another, in the subdivision context, the conditions of approval always come up about the posting of performance guarantees. If there are some sort of public improvements that are going to be made, a road that needs to be built, then you want to have a specific condition of approval that addresses, how that performance guarantee is going to be handled. If you've had some outside reviewer, let's say you had an engineer help on some particular application, another condition of approval is that before a building permit is issued, the applicant reimburses the town for that outside reviewer's, fees, because that's allowed for under your ordinance. Trying to think, this example I had about the landfill up in Norridgewock for waste management. I mean, there were a number of conditions of approvals that the planning board imposed, because one of the issues that the neighbors had spoke quite a bit about was odor. And so waste management, as the applicant, put together this odor complaint response plan, but it was new. And so the planning board doesn't really know how it's going to work. But odor control is one of the requirements of the site plan ordinance up in Norridgewock. So what the planning board did there is they have a condition, they added a condition of approval that says that at a minimum once a year, the waste management has to come in and give a report to both the planning board and the select board about how many complaints there have been about odor, and then what waste management has done to address them. So that way there's like an ongoing dialogue, because there's a concern that this proposed odor complaint response plan that's new may not work just as everybody anticipates, they want some ability to review that on an ongoing basis. And again, there is a nexus between this requirement of an annual meeting between Waste Management and the Planning Board and Board of Selectmen, because it relates to a substantive review standard in the ordinance about odor control. So those are just some examples, but on big applications, typically, the conditions of approval are one of the most important things that the planning board crafts, because it makes sure that, all the concerns about an application get specifically addressed. And it's not just, yes, your site plan is approved and the applicant's off to the races. There are some things the applicant has to do sort of make sure that it is going to continue to be in compliance with your site plan review standards.
One of the most subjective things that we've ever dealt with, and we always deal with the commercial site plan, is the article on noise. Noise is such a subjective thing, and we've even tried to create an ordinance in Lincolnville having to do with decibel level control and that sort of thing, and found it almost impossible. But we just had an application where we had a motel that wanted to do events in the back under a tent, but we had people just, writing in saying noise was going to be an issue. And we really have no means of measuring or even getting, some remittance on it if we have to, because you can't really decipher what's noisy and what's not noisy in everybody's own personal opinion.
Yeah, noise is always a really tough issue. And unless you have some, just calibrating and just A, getting a noise meter, and B, getting it calibrated correctly, and C, getting somebody that knows how to use it and can use it when the activity is happening. Those are all very difficult things to do. And so, yeah, noise is an issue that many, many communities struggle with. It's just, to really address it properly, you have to have a very sort of sophisticated ordinance, and the personnel to, enforce the ordinance standards. Any other questions about conditions of approval? Okay, moving on. We're getting to the end here. Oops. Written decisions. The reasons, and some of this, just so you know, is in the written materials. The reason the planning board has to prepare a written decision is, number one, by state statute, as I said, the Freedom of Access Act, it requires a written decision anytime you deny an application or you approve an application with conditions. So it's in state statute, but also your land use ordinance and your subdivision ordinance both require it. So we can talk about the different ways to do it. One way is to have a fill in the blank form, and that's that sample that I mentioned earlier that Booth Bay has for subdivision. And you could have a similar one for site plan. I would say that, and why do you need to have this written decision besides just, your ordinance requires it, state statute requires it? It's in part also that it's sort of a check on you as the planning board to make sure that you've gone through and checked all the boxes and that you have ensured that there is evidence to support a positive finding on each of the review criteria. So it's in effect a checklist for you all to make sure that the applicant has both submitted and that, information to address each review criteria, but also that the information supplied is sufficient to show that the applicant meets the relevant review standard.
Sally, I'm assuming from the way you're presenting this to us that the written record of a meeting with a decision is not a written decision of the board.
I'm not sure I understand your question, Jay. Sorry.
Every meeting that we have has a written record. It has the discussion that took place, the votes that took place, the decisions that were made, the vote was made on finalizing and approving or disapproving. That is not, from what you're saying, the written decision.
Correct.
Okay, so aside from the record, which has all you just outlined in it, we also have to do separately a written decision that was met by the board.
Absolutely. On a subdivision application, absolutely, because it is required, because the next step is Superior Court on a subdivision application. I would say it's also required you have some kind of funky language. I'm not sure that it's totally consistent with Maine law, but there is some language in the site plan ordinance that says that that findings of fact requirement can be met through distribution of minutes. I'm not sure that necessarily comports with the law, especially if there's been a denial and especially if there are conditions of approval attached. But again, I think on the site plan, you can have a form document that is used and can be, filled out on the fly as you go through it. And it serves as a checklist. It's, as I said, Booth Bay does that on both subdivisions, and they have a similar document for site plan. The site plan or subdivision template is relatively easy because the subdivision review standard are dictated by state law. So every community in the state of Maine is applying the same subdivision review criteria. There might be some local quirks here and there, but generally speaking, it's all the same criteria. Site plan is very specific. Like, Lincolnville has these, good neighbor standards and design standards. So that's all very Lincolnville specific. But it doesn't, you ought to, figure out whether, there is already some sort of a template. Cause I just know when, some of the prior planning board members, like Lois Lyman, she was big on checklists and things. So those may already exist. It may just be that, they need to get updated and you need to start, using them again. But the other key point on the written decision is it's sort of a check on the planning board to make sure you go through all the relevant review standards, but also it makes sure that the interested parties, know what's the basis for your decision. If you breeze through and say, oh, the applicant, met all the review criteria and, I move to approve the site plan application, that's not really fair to the applicant or the neighbors about, I don't think you've sort of done your jobs if you do it that sort of cursory. And I know you don't do it that way, but I'm just, saying. But it's important that all the interested parties know, what your reasoning is. And I also, as board members, you may vote against some, finding that the applicant, meets, say, the, traffic safety standard. If you vote no, I think it's how you ought to state on the record why you don't think that the applicant has met that standard. Just voting no without giving a reason doesn't really inform anybody. And again, if there is some later, challenge, that's, it's not helpful to not know on what basis that, Jay voted against the traffic safety standard. And you might be able to persuade, if Jay thinks the traffic safety standard is an issue for the applicant, then maybe some other board members think so too. So you ought to, have that discussion, hash it out, figure it out.
These templates also, though, give a good guideline for how to word a motion.
Correct.
And to get the facts, the finding of the facts into the motion. I think
Correct.
These are great, and I'd be happy to use these templates to make them more appropriate for our use. And if there's something in the past, that you have already, Jay, I'm happy to use it, but this would certainly make things easier for those like me who are brand new to this and had no clue where to go with the finding of facts. This is great.
One thing I will say about the written decision is that it has to be the board's written decision. It can't be that you go through all the review criteria at your planning board meeting, and then you say to Frank, will you go write this up? This is our decision. And then Frank writes it up and sends it out to the applicant. The law is very clear that, and I know these written decisions are a pain in the butt, but it has to be the board's decision, meaning the board has to formally vote on the written decision.
Mhm.
It can't just say, well, this is what we, voted, read the minutes and draft something up and we're good. That's not what complies with the law,
I
unfortunately.
like your idea of the fill in the blank. At least it's there for us to
Yeah.
fill in
Yeah,
as we
and
go.
I probably went overboard in giving you this Richmond example just because I wanted you to know like what some of these do look like. I am not suggesting that this is what your run of the mill sort of minor site plan and application written decision should look like. But I wanted you to know what it has looked like in some case. My example about this Norwalk waste management landfill expansion project. In part that was why I was at all these planning board meetings, was because my one major task was to draft the planning board's written decision, and it was 10 pages.
Kelly, I'd like to bring up a point and have a little discussion on it that Elizabeth just brought up when she mentioned drawing up these guidelines or these decision letters that would be relative to Lincolnville. And she mentioned, if I have anything, I want to go back to discussion amongst the board and all those points that you made at the very beginning of this thing about not talking to each other, not meeting and discussing. You kept using the word application. Discussions between board members on procedural items, are they allowed? In other words, can a member call another member of the board and say, we got to talk about this procedure we're using for doing so-and-so, having nothing to do with an application, but having to do with board procedures. So if Elizabeth and I got together and said, we're going to refine this decision letter we're going to start using on the board, is that allowed?
I think if it's just two members talking about, working on forms, you're sort of a subgroup, I think that's okay. But once there are three of you, then that's a quorum, and that ought to be done in a workshop.
Okay, that's a good point, because we used to have workshops way back in the early 2000s. In the wintertime, when we didn't have anything to do, we got together and had workshops. And we, as a board, met and discussed what we were all experiencing. The new members got to hear the older members talk. And that was very, very productive. I'm so taken aback by these new members that are coming on the board, and they just have no training. They have no ability to discuss with anybody else what's going on. It's rather non-constructive, in my opinion, in getting a planning board member up to running speed. It's a very steep learning curve in the beginning, and there's no means for them to learn anything. It's frustrating.
That's why I got roped into this. Yeah, I mean, the town the select board, it's in everybody's interest to have, to give, new board members the tools that they need so they can do their job. And so the town is willing to make these resources available. It's unfortunate that the training that, some board members went off to for MMA, you didn't find it that helpful, but I think your idea of, having some workshop sessions, because it may be that you got to start working on maybe some of your forms, but B, you may want to talk about some things in the ordinance that you think might need to be changed. Because again, I can just tell you the procedures for both site plan and subdivision they seem a little bit onerous, and I don't think it necessarily needs to be as long as it is. But that's what the law is now. So you can't shortcut the process, and you can't sort of not follow what the ordinance requires. But maybe it makes sense, you got to follow the ordinance for now, but maybe there's a suggestion that you streamline some, it doesn't need to take, 6 meetings to approve a site plan application necessarily.
One other point, and that takes me back to page 6 on the quasi-judicial and legislative roles that you put in the paperwork.
Yep.
On the legislative side, the very first bullet, it says you may talk to as many people as you like outside of meetings, and you should study the adopted comprehensive plan. Parentheses says, but don't talk to other board members. How do you get anything done if you can't talk to other board members?
In what business is it that you're talking to other board, or that
changing an ordinance, creating a procedure, coming up with a different ordinance? We don't have a land use ordinance like we used to. They're the ones that wrote the ordinances. I was a member of that for many years. That went away. If ordinances are discussed now to be changed, created, or whatever, it's discussed at the planning board. I assume that means we're in legislative mode and not quasi-judicial. And if we're doing that, what you're saying here is we can't talk to each other. I find that confusing.
No, what it means is you need to have that discussion at a public meeting.
Oh, okay, all right.
It's
And
not-
if
that's-
I-
We're not saying that the workshop. You can
Okay.
absolutely, you can talk about forms, you can talk about, well, maybe we ought to tweak the site plan provisions, maybe we ought to, tweak the subdivision. That you absolutely can talk to your other board members all you want in a workshop setting. What this, and this is supposed to be a handout, when you as a planning board might be considering amending the ordinance that's going to be adopted by town meeting, you shouldn't be talking to your other board members about that, generally speaking, because that's planning board business.
Okay, that
And
clears that up.
outside of the public meeting, you want to, you can talk as much as you want with your fellow board members, but do it at a public meeting so everybody knows what's being said.
And I take
is-
from the way that was presented that you can also talk to anybody else in town about that.
If you're talking about ordinance amendments or your paperwork, yes. If you're
Okay.
talking about the, whatever, Motel 6 expansion, no, you cannot talk to anybody, be it the applicant, the neighbor, your fellow board member, about the Motel 6 expansion application.
Okay,
If, as chair or any member of the board chooses to do the research, how does that research get conveyed, like for Motel 6 prior to a meeting? If the research is strictly, here's a timeline of what has occurred at that commercial site over the last 50 years, can I email those details to everyone? Or is that also
Right.
something that has to wait to be presented at the meeting where they then are not prepared at all unless they've decided to do the research?
Okay, 2 points that you may raise, one that want to be very clear on. Number one, about research. And the other is about emailing information to fellow board members. So on the point about research, part of being a judge is that you're a judge. You're not a prosecutor. You're not a defense attorney. You don't do independent investigations. If there is information that you think will help inform your decision-making, you ask whether it's the applicant or, the neighbor that's got some point they think is important. Well, you ask for that information to be submitted to the board as a whole at a public meeting. You do the same thing about like site visits. You don't do drive-by site visits. You see that next Wednesday, the Motel 6 applications, you're gonna go look at the site. No, that's a huge no-no. You are not to do your own independent investigation. If there's information that the board thinks, will be helpful, you ask whoever, is the appropriate party to submit it to the board as a whole, and you don't do research yourselves.
Does that include research of just looking at the old commercial site plans?
As relates to a pending application, yeah, I would say that is doing research and that is not
Okay.
appropriate unless the board as a whole decides they want you as chair to go and look at prior commercial site plan applications and bring that back, and you're going to share it again with the applicant and the neighbors and all of your board members. It has to be, and if it's okay for the board to have sort of some investigative work done, but it has to be authorized by the board and it has to be shared with everybody, the neighbors, the applicants, the fellow board
But at the
members.
meeting?
At the meeting, right.
Okay,
The point is that everybody, the planning board should all be making its decision based on the exact same information. So if you, Elizabeth, have some information that the rest of the board members don't have, and that informs your decision making, that's not fair because nobody else knows that that's important to you, and nobody else can respond to it. But also, it might be helpful to your other board members, and so it's not, your individual, the 5, voting members all get to pick and choose what they're going to base their decision on. It should all be based on the same set of information.
okay.
And the other point is that, and I didn't want to browbeat you too much on the Freedom of Access Act, but it is a huge no-no to be sending emails around to one another because those can quickly turn into meetings via email.
Yeah.
So be very careful about the reply all. Quite frankly, for a lot of our boards and committees, we say that, when stuff is sent, materials are sent out to board members. We have it sent out, let's say Dave Kinney's sending, materials out to the board, or Frank is on an application, send it to, Frank sends it to Frank, and then in the BCC, he puts all the planning board members, so that if somebody hits reply all, they're only replying to Frank and not to all 7, 5
Yeah.
and 2 alternate planning board members, because that gets into trouble. And also you want to be careful. Another thing, this is hopefully already the practice of the town, but if the applicant submits something, that should get shared with everybody, not just the planning board, but even the neighbors who are interested in application. And same thing, if the neighbors send something in about an application, that shouldn't just go to the planning board members. It should also go to the applicant. Again, it's this, everybody needs to have the same information. And you have to be scrupulous about and if you as board members get emails about a particular application, you need to make sure that everybody, knows that those have come in. And you may need to just make a reference to them that, on this Motel 6 application, I got 3 emails from neighbors over the weekend, and here's this, just do a little summary, and here's the substance of their emails, so that the applicant knows that you all as planning board members have received those.
Okay.
Because those emails are what are called ex-parte communications. It's
Mhm.
information being received outside of the context of the meeting. It's not the grocery store in person, but it's via email. And those are
Right.
the same thing. They are ex-parte communications.
Okay.
And that, unless you all have other questions, that's all that I have for you. But I'm pleased to stay as long as you would like to answer further questions.
I don't want this to go on too much longer because I think everybody's getting a little bit under the weather, but you didn't really cover too much the importance of findings of fact. I didn't see it mentioned, and I think that's an important point because a lot of members, in order to get a meeting done or something like that, will just go over an item that's being covered in a standard and say, I approve that, but there's really nothing in the record that shows the facts in the record as to why that was approved. I found it very interesting in the material you sent out on the main court decisions. And on the next to the last page, there was one that says from Rudman, a judge, although I concur in the opinion of the court, I feel constrained to write separately to advise the Bangor Planning Board of similar boards what seek we remand for findings of fact. We have on at least 3 occasions recently remanded pending cases back to the boards for review of the case, re-review of the case, because the planning board's findings of fact determine whether the findings are supported by substantial evidence. The findings of fact are insufficient to appraise us of the basis of the board's decision. It is impossible for us, that being the court, to determine whether the decision is supported by substantial evidence. That judge said that because it was the third case remanded back to a planning board because the findings of fact were insubstantial in the record. So he's pleading with planning boards to please present in the record the reason why you approved this or that, or did not approve this or that, or disapprove this or that. Because when it gets, term of a subdivision is going to go to district court, the person in the black robe is going to be reading that record. And if there's no facts there for them to look at, it's coming back to the board with no question. Just redo it again.
Well, that's the whole thing about the written decision. And again, if you want a sample, look at the Richmond one. I mean, you can see that the board, it lays out what the standard is, and then in italics, you can see that's I'll give you an example. This is on page 34 of the written material. So one of the standards in Richmond is about glare. And so the planning board makes a finding that the proposed use will meet this performance standard based on the following evidence. And then the planning board has filled in that according to the testimony of the applicant's engineer, Stephen Bradstreet, all lights on the building will have cutoff fixtures, meaning that they will shine down, not out. Parking lot light fixtures will be hooded so that they shine downward and not into the street or abutting properties. In addition, all exterior lighting will be on a timer that is programmed to shut the lights off when the store is not open. The vote on this criterion was 5-0 in favor. So I was trying not to hit you over the head too much with this, but that's what findings of fact are. That's your written decision. So I think it would be helpful to have the template, but then you can see, that there does need to be some reference to what it is about the application that demonstrates that the applicant has shown that it meets the substantive review criteria. It can't just be this standard is met.
Right. Now, that's why I like this. This is a great place to start. Thank you.
When done right, it's a fair amount of work, and so you got to balance. I think again, this Richmond example is maybe more than you need to do on just your minor site plan application, but you can see what what you need to be working towards as far as at least referencing what it is in the application that shows that the standard has been met.
Great. Any other questions, guys? You guys have been all so quiet.
Like taking a drink from a fire hose.
Yeah. Well, that goes back to my point about planning board member. I mean, a person who raises their hand in a small community and says, I want to be on the budget committee, it's understood they probably have some accounting experience. They probably have dealt with budgets. Anybody for the school committee probably has a child in school, or they have education experience, or they're a retired teacher. But somebody raises their hand for the planning board, the amount of teaching that goes into the teaching these volunteers to take this position is just minimal. And I feel for some, I've been doing this for 20 years and I still find things on a daily basis that I haven't seen or dealt with before. See people coming on the board initially the first year or so, like Sandy said, it's like drinking from a fire hose. It's very, very hard to get on. But we have 4 or 5 ordinances. They're all different. They're all applied differently. The processes, the procedures, the history, all that stuff takes a long time to get acquired and start to utilize it in an efficient manner. It's a tough nut. Sometimes it's enjoyable, sometimes it's not, but it needs to be done. But I think the town needs to make an effort somehow to try to get people a little bit more familiar with the ordinances. I don't know if it's going to require some qualifications that needs to be looked at when the select board is selecting people, or whether we need to do training or something, but it's tough for new members. Elizabeth's very first meeting, she was elected chairman. I mean, it's I felt for her, but she held up her hand and said, I'll do it. And she's doing a great job, but wow.
I held up my hand and said no after someone nominated me and then accepted it, thinking I was just going to be managing you guys and telling you when you could talk and when you couldn't. There's a lot more to it than that.
Yeah.
David, I don't know if you were listening in on that, but I will, if not, I will relay the comments to you next time we talk from the planning board about training.
Mandatory training. A lot of towns have it.
Yeah. And it's more than just knowing about the Freedom of Access Act. I mean,
Right.
that's just about meetings, and you could spend 2 hours training on that and not even get into the the substance of what it is that a planning board does. I would recommend 2 things. One is for new members, and I know it's a slog, but it makes sense to at some point sit down with the site plan provisions and the subdivision ordinance and just read it through, just because that's what you're gonna most likely to see. And
I
then,
thought that was a given. So I've read
Yeah.
all of it several
Yeah.
times,
Yeah.
but it doesn't stick in my brain. I haven't been at it for 20 years.
It is a
And then I-
given, Elizabeth.
It is, it should be a given. Everyone should have read it,
Yeah.
all of it, including the MMA manual. So
Yes.
I think one thing that's kind of misunderstood, and you pressed it, Sally, when you said it's a quasi judicial board. When you hear that word judge, people think that they're going to join the planning board and sit in judgment of an application. And that's really not the case. What you're being asked to do is to look at an application in terms of the standards that the town of Lincolnville's residents have established as the development criteria for their town. You're just making a decision that the application meets those standards. That's what it's all about, not sitting as a judge determining
There it
whether
is.
you're.
That's what judges do all the time. They apply the
Right.
facts to the law. They find
Yeah.
the facts and then they apply the law, facts to the law, or the law
And
to
so
the
when you're out
facts.
recruiting planning board members, it's important that you make that stipulation that all you have to do is sit there and know the standards and look at the application and say, does that application meet the standards?
Well, in my case, the reason I'm here is I was told there were 3 empty openings on the planning board and that somebody needed to step forward and fill them. I had no clue what a planning board did. And I'm not certain I do now.
Well,
But,
good for you, Sandy, but yeah.
Civic duty, but oh my God, what the hell did I get into?
So yeah, I think that it probably makes, if you have follow-up questions, I'd say get them to David and he'll pass them along, because I mean, I think, again, the town wants you to feel like you have the resources that you need. And maybe for newer board members, you work at it for a few more months, and it may be that you decide in 6 more months, you might want to have a little refresher, training kind of thing. But I think it probably makes sense to work on some templates for your written decisions on site plan and
Definitely.
subdivision. I think that will just help you. That can be how you, go through the review criteria.
Yeah.
One of the things that we don't receive, we don't have anybody necessarily looking over our shoulders, critiquing our process or how we do things. I know the selectmen are responsible for that, but I can almost assure you nobody goes through our meetings minutes online and picks up on something that we probably ought to correct.
It's all there. If you request from the town a video of any particular meeting, they'll provide it for you. The agendas and the minutes are all online. So any history of anything that's been decided is all there if you want to go looking for it. So that can be done. And yeah, I've done that.
I guess the point is, I know I can go find things if I needed to, but if we are doing something that we could improve and there's no one there to point it out to us, how do we know about it?
Well, I don't want to get into the specifics, but as you know, there was a recent appeal of a planning board decision to the Board of Appeals. So I think in that sense, the Board of Appeals has weighed in at least on one of your proceedings. And again, I don't want to get into specifics, but so that's a bit of a check on you. And I mean, that's something you want to talk with, Dave about. Is there some more, training that you guys might like, maybe, in 3 or 6 months? If you feel like, you're not there yet. And I'm sure that the town will say yes. I mean, because quite frankly, it doesn't make sense to have board members feel frustrated and quit. And it also doesn't make sense for the board members to not, have the tools that they really should have, and then to make mistakes, not intentionally, but just because they didn't know any better. And because those mistakes, they lead to appeals, they may lead to, God forbid, litigation. But and I will say this: don't be hesitant to make a decision when you're not ready to. That's advice I give to all planning boards: is don't let, whether it's the applicant all applicants, want their approval yesterday. They've got something, some timeline that they, that's unreasonable, but you all have to, accommodate their timeline and not necessarily what the ordinance calls for. But you should not, if you're not ready to make a decision, then you shouldn't be making a decision. So it's okay for the board to slow things down. And it's okay to say, there's more information that we need. And so we're gonna, table this application tonight, and we're gonna come back, at the next meeting, because there's something more that we want. We're not ready to make a decision tonight. And I know it sounds easy to say that, and it's hard to do in practice, but you have that right to do that. You, to get, you ought to be making informed decisions and not just making decisions for the sake of making a decision because the applicant wants a decision. You want the process to be, fair and inclusive and thoughtful for everybody involved. So. All right, if anything else that anybody wants to ask? All right. I'd say work on your written decision templates, and then if you have follow-up questions, something you forgot to ask, just get that off to Dave and he'll get it to me, and we'll go from there.
Sally, thank you.
You're very welcome. Thanks everyone
Thank you,
for being such
Sally.
a
Thank
good
you very
audience.
much.
Yeah,
All
Sally.
right. Thanks everyone. Have a good
Good
night.
night.
Bye.
I love the idea of us getting together when we're not having a meeting. Obviously, you can't do that in the same room, so will it be as effective, Jay, as you used to do? I think Jay's frozen. All right. Good night, everybody.
Good night. Good night. Irving. Good night. Good night.